Bom dia.
Good morning, ladies and gentlemen. Let's begin the event Just Without Frontiers, the Seek for Reparation for the Disaster in Mariana, organized by the Pogust Goodhead law firm with the support of JOTA. I'd like to call Ana Carolina Salomon, who is an associate and chief investment officer at the Pogust Goodhead and leads financing field. Anna is a specialist in structuring of financial assets for transnational and local cases involving human rights, protection to the consumer, environmental damage, and climate litigation. With formation in tax law and financial law in Brazil and in England, she worked in investment banks, management of assets, and law firms specialized before concluding her global program executive MBA and UNICED. She's an active voice in the sector of impact investment. Anna, you have the floor. Thank you very much, Anna. Good morning. I'd like to thank you of everyone this morning. That's so meaningful and important for all of us. I also thank the ones who will follow us online for their presence through YouTube platform with the media support from JOTA. It's a huge pleasure and an honor to host this event that is so meaningful to us, that brings up such important discussions such as borderless justice, access to justice, and notably the reparation of the damage occurred because of the Mariana disaster that already happened over 9 years ago. Nowadays, today we have the privilege of gathering Brazilian authorities, professionals from many fields, and the most important thing, clients of Pogust Goodhead, the ones that were personally or indirectly affected by this horrid disaster. On behalf also of their dear family members that were affected by this disaster, I'd like to thank everyone. On behalf of the Pogust Goodhead law firm, I wish you all a very good event to enrich us all on this matter, on this subject. Fernando Moraes is a journalist, politician, and writer. He's born in Mariana. He built his literary work producing biographies and major reports that ended up becoming very well accepted books with our President Lula da Silva, Assis Chateaubriand, and Paulo Coelho. His first editorial success was The Island, a report from a journey from the author took to Cuba in full dictatorship, the work that provided opportunities of exchanging texts as a journalist. He's a head of Enterprise Service, an international news agency with 59 years of service, with offices and correspondence in the 5 continents, that has the goal of taking information on marginalized groups to the whole world. I'd like to invite Fernando Moraes to take the floor. Thank you very much. Good morning. Good morning, ladies and gentlemen. Good morning, everyone. I thank you very much for the honor of being here, not only as an activist, as a militant, a political militant of the good causes, but also as a double client of Pogust. Once, beyond being from Mariana, I found out I'm not the only one from Mariana here. Have just been introduced to a fellow person from Mariana that was much more victimized than I in the crime committed by Valley in my city, our town. And beyond being from Mariana, I have another cause which is being stood for very brilliantly by the office here in Brazil, by the law firm here in Brazil. And when they established the norms to talk, the talking rules, so to say. I said the former congressman or former representative doesn't talk for only 15 minutes. I will steal some more time, but I'll promise you it won't be much more. I want to say that I think it's time beyond beyond maintaining the insane fight that Pogust is leading. The time is also for reporting Valley for the indecent propaganda campaign it holds in the whole world in Brazil to try to erase the ghosts of the crime it committed. It needs to be clear. Our Rodrigues said, "Love buys even." That money buys even sincere love. Vale needs to know that money doesn't buy lives. Can buy sincere love, but doesn't buy lives. It's no use to buy prime time in TV channels because this won't erase the crime they committed. What will somehow try to stop strategies like the this one to happen again is the seek for reparation for the disaster. I, as a person from Mariana, obviously was very much affected by the crime perpetrated by Vale. When I say Vale, I mean all its associates, its partners, and I fed the hope that we could win the company over when I found out the law firm uh, had said it would do the defense of the municipalities, the people who live in the region, pro bono, without any legal fees, and standing for especially the people who lost their lives. But when the amount established by our lawyers, even lost hope, and I decided to sniff around, so to say, what we have similarly, at least in our surroundings in Latin America, similar things, similar issues. And that was when my not anymore hope, but expectations of us being winners in this cause was reborn. There are two cases I will summarize very telegraphically, so to say, that make our hopes reborn, our expectations reborn that this will be a victorious battle for us. The first of them is the famous case of the indigenous nations from Ecuador against Texaco Chevron, which is a notorious case where Chevron contaminated with 650,000 barrels of oil, disposable oil, contaminated the soil, compromising the lives and the health of thousands and thousands of indigenous peoples. And when they found out they were being sued, Chevron pure and simply removed its assets from Ecuador and spread them through worldwide. And the law firms went after them, inclusively in Brazil. In Brazil, when justice went after indemnizations from Chevron, found out the account of Chevron in Ecuador had $350. A company that has a revenue of 250 billion US dollars per year. We won. We won 9.5 billion US dollars. Second case, that if it weren't so dramatic, so criminal, could be seen as one more story of fantastic realism of Latin America, which is the war of water war in Bolivia. 1970, in the first semester of 1970, General Hugo Banzia did a coup in Bolivia, and then after this coup, he remained another 4 years. And after Afterwards, he was elected president in the year of 2000, elected by the population. Sorry, I apologize, he says. Brasilia, we get a dry mouth in Brasilia. We're having like 7% air humidity here these last days. Thank you very much. But General Hugo Banzer, already elected president, he decided to privatize the water supply system from Cochabamba City, the third most important city in Bolivia, now with 800,000 inhabitants. And winner of the privatization, a company called Aguas de Tunara, which is the Hispanic code name of the North American Airtel, it decided, first thing, naturally, was to double the tariffs of what was paid by the population from Cochabamba for the water consumption, fresh water consumption. And the price was very high, especially for the poorest population of the city that decided to do the obvious, buy water reservoirs, plastic water reservoirs, place them on top of their houses to gather rainwater and use that for the domestic consumption, for domestic use. Bento uh, got the Benzo to issue a law forbidding the population to put water reservoirs on top of their homes because that was considered uh, unlawful. Unlawful competition with the company that had won the procurement for privatization of the service. To summarize the story by just uh, bit, General Hugo Banza wasn't overthrown, but the law was made illegal, was revoked, and the water supply became public as once it was. And I would like also, I couldn't avoid doing it, even because of a public thank you for the help that Pogust is providing me. Like some of you, ladies and gentlemen, know, I'm writing the biography of our President Lula. I published the first part, and I'm heading towards closure of the second part. And I began when he was still in prison in Curitiba City. I remember having gone to fetch uh, the power of attorney in prison from him, and I opened a request of annulment in the intelligence security institutions of North America, CIA, FBI, NSA, to lift all the existing records about President Lula since the moment in which he uh, was associated to the metal workers of ABC Union. And 5 minutes, okay, I'll have time. Uh, in whole, if not mistaken, there were 16 agencies in which we seeked for information. After a lot of difficulty, it fell from the sky. This very dear help from the professionals I can now call companions from Pogust that decided pro bono to join my war, my struggle against the intelligence institutions of the United States of America. First good news came out a few weeks ago, and I suppose I can make that public. Philip is looking at me with an Egyptian look, but what is here has no secrecy still up to now. We already managed to to join to gather the following documents to join, get them into the lawsuits. 200 documents related to President Lula, being 613 of them produced by the Central Intelligence Agency. In whole, they are 3,000 pages of information in whole, from which only to take a look are only to mention a few things. There are political relations or relationships between President Lula and President Dilma Rousseff. Contacts with President Lula with contacts from the Middle East and China. Military plans of Brazil dealt by President Lula. Themes dealt by President Lula related to the production of oil from Petrobras, the Brazilian uh, oil company. 30 documents from the Department of Defense in a total of 180 pages. A document from our cyber command of the Army of the United States, in total about 50 pages. 8 documents originated from U.S. Southcom, United States South Command. It's a military base of the Navy, the Air Force, and the Army in the south of Florida, which is a kind of civil guard of the Southern Hemisphere. It's the boss of the Southern Hemisphere. In the archives of the U.S. Southcom, we located 294 pages about President Lula, 49 documents from the DIA, Defense and Military Intelligence of the Department of Defense of the United States. In total, 253 pages. 111 documents from the Department of State, totalizing 437 pages, and the already mentioned 613, the already mentioned 313 documents originated or from the CIA. That is totalizes this first lot that the law firm had access to, in a total of 2,199 pages of secret documents uh, coming from snooping around, so to say. These are wires and espionage, and that will be in our hands the sooner as possible. So I'd like to say, I didn't go over my 15 minutes, but I'd like to say that to me, it's a reason that is double gratifier, so to say, to be here not only as a person born for almost 80 years ago in Mariana, but also by the fact of being able to uh, unbury a part of Brazil's history was subtracted illegally from Brazilian authorities, particularly from the the present, our president of the Republic, President Lula. I want to thank you very much. I want to tell the Pogust professionals that I insist in calling companions because the cause is the same, and thank as a person from Mariana, as a journalist, as a researcher, but above all, as a citizen, uh, liberty loving citizen. I'm sure we will win both struggles. Thank you very much.
I would like to now invite to compose the first panel Tom Goodhead, José Eduardo Cardozo, Caroline Prone, and Valério Mazzuoli. Tom Goodhead has a degree in political philosophy economy by the Oxford University. He also has a master's degree in politics and educational politics by the Cambridge University. Afterwards, he qualified as a lawyer with a degree in City University in London and in the University of Law. He's a co-founder, CEO, and administrative partner of Pogust Goodhead. José Eduardo Cardozo is a lawyer and Brazilian politic. He was the Minister of Justice and General Attorney of the Government of Brazil. Caroline Pone is the professor of the General University of Rio de Janeiro. She's a lawyer, a writer, a legal advisor, and a speaker. Valério Mazzoli is a professor of the Federal University of Mato Grosso. He's a doctor by the Federal University of Rio Grande do Sul, a master in international law by the University of São Paulo.
I'm afraid, being a typical Englishman, my Portuguese isn't good enough to speak to you all in Portuguese today. So I would suggest everybody put their translations on if you're not fluent in English. And again, apologies for the lack of Portuguese. Good morning, everyone, and thank you to JOTA for hosting this event, and thank you to my esteemed panelists who are joining this morning. Before we start the panel, I would just like to speak, maybe just for 10 minutes, a little bit about the case in England and some of its impacts from the perspectives of transnational litigation, the ability to hold companies accountable for environmental crimes, and some of the issues which are live in the case, to give a little bit of an insight into what is going to happen over the next couple of months. I'm especially grateful this morning for Fernando de Moraes' incredibly warm and welcoming remarks, and for his solidarity in relation to this fight, which has been ongoing now for nearly 9 years since the tragedy, and this case itself for nearly 7 years. And also welcome to some of our clients who have joined us this morning from Mariana Wakrewa is here, Gelvana, and I'm extraordinarily moved every time that I hear their stories, and perhaps some of you may get the opportunity to hear from them today as to the impacts of this disaster upon them. So to begin, what is this case? This case is a case which is continuing in the London courts against BHP. And the reason that the case was brought in England, because BHP was an Anglo-Australian mining company. So it was a company with a dual corporate structure, listed on the stock exchange in London as well as in Melbourne. And of course, as a result of their 50% ownership in Samarco, this is a company that has made billions and billions, if not tens and billions of dollars out of the mining sector here in Brazil. And it's a company with operations in Chile, in Peru, in the United States. So it is the very definition of a transnational mining company, the largest mining company in the world. And the reason for this case, with over 600,000 people claiming in England, together with 46 Brazilian municipalities, tens of thousands of people from traditional and Quilombola communities, as well as thousands of businesses, has been a struggle for reparation. The companies committed this crime nearly 9 years ago, and I use that word very deliberately. It is a crime. And as to this day, a majority of those who are proceeding in the claim in England have not received financial compensation or adequate financial compensation. The same for the municipalities, the same for everyone who has been part of this struggle. As well as, of course, here in Brazil, as has been very well publicized, nearly 9 years on, negotiations are still underway in relation to holding the companies finally accountable for the crimes that they have been committing here in Brazil as well. So this is a struggle for justice which has gone on for a very, very long time. But what I thought it might be worth just offering a couple of words on this morning is the transnational nature of this litigation. Because what the companies have sought to do, there has been an ADPF, which I think some of my panelists will speak about this morning, filed in the STF, seeking essentially to it be held unconstitutional for Brazilian municipalities to litigate overseas. And they've referred not only to the Mariana case, but also cases that municipalities have taken in Germany as well as in the United States. And it's amazing that the companies, and BHP in particular, BHP, who we found funded IBRAM to bring this claim, they weren't brave enough to do it in their own names, as they knew that they wouldn't have legitimacy. So they hide behind a mining association in order to do it. That they use the language of sovereignty, and they say that this is an impingement upon Brazilian sovereignty. Now, I would suggest to all of you that the irony is this is an Australian company, a British Australian company that has plundered Brazil's resources, making billions and billions, if not tens of billions of dollars over decades, to then turn around and then use the veil of sovereignty as a reason to say that Brazilian municipalities shouldn't seek justice overseas. It's absurd. I want to suggest to you all today that actually, rather than this being some form of neo-colonialism of an English court asserting its jurisdiction over Brazilian affairs, this is in fact quite the opposite. This is a case of ordinary people from across the Rio Doce Basin, mayors, some of whom have never traveled outside of Brazil before until they were doing this case, people from traditional communities, from indigenous communities, who have taken the fight against BHP, an English-Australian company, to the courts in London. So rather than it being something which is neo-colonialist or an infringement of Brazilian sovereignty, what it is actually doing is exporting Brazilian law to a tribunal in London. And that's the case. The case is decided under Brazilian law. So the concept of being a polluter under Brazilian law, the calculation of damages, that's all Brazilian, and it is against an Anglo-Australian company in the London court. So this is effectively Brazil asserting the long arm of its environmental law and taking it to a court in London. So it's why this rhetoric about sovereignty, frankly, is so absurd. It's nothing more than the companies seeking to evade their responsibility for this disaster, just as they've done for the past 9 years. And I know we have many renowned criminal lawyers in the room here. And one thing, sadly, about criminals is recidivism. Criminals tend to do the same thing again and again and again unless they've been rehabilitated. And BHP, I'm afraid, have not been rehabilitated. I would encourage all of you to read online about the story of Papua New Guinea. OK Teddy. In Papua New Guinea, BHP did exactly the same thing. A tailings dam collapsed, extraordinary pollution of waters in Papua New Guinea, and a group of Papua New Guinean citizens sought to sue BHP in Australia, in Melbourne. So what does BHP do? They make it a crime. So they procure the Papua New Guinean government to pass a law to say that it is illegal for Papua New Guinean citizens to litigate against BHP outside of Papua New Guinea, and they end up with the lawyer being arrested and detained unlawfully in Port Moresby in Papua New Guinea. That was BHP. BHP were found in contempt, which is a crime in England or in Australia by the court, and they've tried to effectively do the same thing again here in Brazil nearly 30 years later in relation to this ADPF, which has been brought, where they're trying to prevent Brazilian municipalities from litigating overseas in order to hold BHP accountable for their crimes. They try to play on the desperation of victims. We've seen things like systems and some of the injustices that have come from the Renova Foundation, which have been so heavily criticised. Mr. de Moraes was commenting upon the advertising that they do, and they try to publicise how good their remediation schemes are, and they've been condemned by the Brazilian judiciary for that. This is a case, I'm afraid, of environmental crimes. And we've seen proposals, in fact, it's in the news today, about ecocide potentially now being made a crime in the International Criminal Court. We've had the example from Mr. de Moraes this morning about the need for him to be working with us to try and act on behalf of President Lula in courts in the United States. I'm sure Minister Cardozo has many examples of where the Brazilian state has needed to take legal actions overseas. There have been cases against notorious criminals in order to recover assets overseas. There have been the orders of COVID vaccines that states have to do. What the companies are trying to suggest through this ADPF is that they will veil themselves in the Brazilian flag and say that this is an attack upon sovereignty. It's not. This is traditional corporatist greed, companies using their deep pockets of millions and millions and millions of dollars in order to try to prevent people from accessing justice. And I'm sorry if I've run slightly over in terms of my time this morning, but I'm grateful for everyone. And I think I'm now passing on to Minister Cardozo to make some more detailed remarks. Thank you.
Very good. Bem, inicialmente, meu bom dia a todos e a todas.
First of all, good morning, ladies and gentlemen. Different from Tom, I'll speak in Portuguese, which is a language that I can express myself much better than in English. I ask that the organizers tell me when I still have 1 minute from stop speaking, because us young lawyers, we are like this. When we are enthusiastic about a topic, we lose track of time and we lose the limit of our speech. I want to salute Carol Prone, the professor, for her presence here, and to tell you that the subject that we are talking about brings me a lot of enthusiasm and some deep reflections. The first plan of those reflections have to do with a moment we're living in humanity, which is very different. Even though human beings, ever since their origin, are in relationships and are joined in groups, the truth is that the world is more and more bringing the relationships closer, and this phenomenon is called globalization. But it's important for us to have in clear sight that the current stage of globalization is not neutral. It goes through ideological and political disputes. Some defend globalization as a way to affirm the exploitation of people, but others defend globalization under a scope of the defense of human rights. These two perspectives are in contrast with each other, and sadly, it calls our attention that even today in our country, we have those who defend the exploitation of peoples and deny human rights. The situation that we're living of the disaster of Mariana that was referred to by Tom shows a merciless situation where two mining companies, without any care, thinking that they were in a country not of the third but of the fifth world, were not careful in their due diligence. They acted in a meaningful manner to cause a huge environmental disaster, making victims, killing people, eliminating businesses, and making that region in the country never able to recover once more after this predatory situation. They took the profits to their lands in the case of foreigners, and in the case of Brazilians, they distributed these profits to their shareholders. And when they were called to be made responsible for the liability, they just stepped aside. And they stepped aside from the land, from the water of the river that they dried. They just stepped aside, and they are gaining time not to pay what they owe. And the situation had made it so that the office commanded by Tom, representing more than 700,000 people, or actually around 700,000 people, would bring a process in England so that these victims could receive what is owed to them according to the norms imposed by human rights. the reaction of the mining companies was not in saying, I should not. Is in saying, well, I wasn't as liable, I'm not as responsible. I should pay something, but let's compensate within what is reasonable. But they did not take effectively the compensation of the damage that they produced. And in Brazil, they are delaying action, postponing actions. They're trying to develop an agreement which will effectively be very low, very below what the Brazilian people have suffered due to that horrid disaster. Very well. We are within a game of interest. But what is most surprising is that these companies have decided to talk about national sovereignty, to not pay what they owe in the English action. The concept of sovereignty is not new. It was brought by in the 16th century. Jean Baudin had brought it in the books of the Republic. But we know today that more and more the world is integrated. And I don't mean that the sovereignty should be eliminated, but we have international agencies, we have dictators that commit crimes around the world. They can be penalized elsewhere. And the international connection is affirmed, sometimes under dispute, but on the one hand, we have the interest of the big capital of exploitation, and on the other hand, those that are looking to defend human rights regardless of borders. Companies want a borderless world for exploitation and but they do not want to pay the damage that they effectively cause on the people in those countries. This type of stand has made the companies do what Carol Prone will say, lawfare. It is a legal war indeed, a legal war brought against those that are defending human rights, the lawyers that are fighting in England, accused in Brazil of being predators and gaining clients unduly, only because they had contracts with clients that could bring an action in England. They wanted the big firms in Brazil not to have not have contacts with their clients. And in breakfast, where they call the lawyers to show the quality of their officers, but those that are working for poor people, for exploited people, for oppressed people. Oh, and they'll say, oh, they're just getting clients unduly. And then they begin the lawfare against the lawyers in Brazil. They attack the municipalities in England represented by the office and saying that municipalities can't act in that. They cannot. The only one that can act in that is the government, the federal government, as if municipalities were third category citizens. And then we have a thesis which is authoritarian from my standpoint, since it is attacking the states. They say that the municipalities are not legal persons for the international law, because only the federal government would have that. And then only the federal government would be able to form agreements for international collaboration. Only the federal government could bring actions. I could not have that in a municipality or in a state. I can't have agreements even for scientific cooperation. That is what the Brazilian federative spirit does not bring by. We should not kill the municipalities and the states. They should do everything except what the common citizen can do, because natural persons can enter into a foreign process. Do the municipalities and states need to ask the federal government before doing that? This is a reactionary and authoritarian standpoint, a standpoint that I would say comes from the dictatorial periods in Brazil, and that is how the lawfare happens in Brazil. The municipality is under the federal government. If they want to buy vaccines, for example, they can't do that. Only the federal government could do that. And they leave the country on the hands of the possible eventual government, which is not the case of the current government. But some government could do negative things, could act authoritatively. And is that what we want in our country? I don't think so. We have then, on the one hand, those that are defending the victims, and on the other, those that are defending the non-compensation of those victims, developing a lawfare to go against lawyers. And I learned in law school that those that are fighting against lawyers do not have a good cause, because those with a good cause do not need to attack lawyers. They go directly to the matter at hand.
The attack, on the other hand, municipalities that can effectively file lawsuits, they say it's a shame for Brazilian justice, a shame lawsuit in England, as if the two lawsuits dealt with the same thing. No, they have different grounds. But a shame, real shame, is not paying for the indemnization. That's the real shame. Don't say sovereignty is being violated, because the human rights transcend sovereignty. Today, the physicians have no borders. Why? Because justice must have borders. There are things I consider, Tom, dear friends, companions of this panel, unacceptable. Reactionary postures, the juridical attacks through a law firm. Why? So the millions sent to England don't serve to pay for hundreds of thousands of Brazilians that suffered with the predatory action of the ones that still think we are a banana republic, the ones that think they only hand out little mirrors that we will pure and simply be seduced as the colonizers did in the past and did with our originary peoples. We're not a banana republic. We are a country that praises sovereignty, but above all, we're a country that struggles for human rights to be fulfilled wherever they should be violated. Humans are humans, and as such, must have their rights observed, respected. So I close here because my time is up, but I repeat, us young lawyers, when get carried away, enthusiastic, we tend to talk more than we do. But I tell you, with the soul of a young lawyer, I am I'm revolted. The ones hit by the Mariana disaster now will be compensated, hurt who it may hurt. Thank you very much. Good morning, ladies and gentlemen, everyone here. After hearing my dear friend, Minister José Eduardo Cardozo, lawyer, I feel like marching into a revolution. So if it's not the first time I leave out very angry with a cause he stands for. I want to greet Valerio Mazzioli, with whom I have a old-time relationship in international law as a teacher and huge admiration. My greetings, and also greeting initially the English lawsuit in law firm in the presence of our dear Tom Goodhead, manager associate and CA from Pogust Goodhead. Also some incredible lawyers I met yesterday: Celine, Leila, Ana Carolina Salomão. There are others. I am meeting women lawyers in England, in Brazil. And allow me also to do a special thanks to the lawyer Felipe Rota, who is here with us. He specifically, on his behalf and his team, of the many law firms with headquarters in Brazil, I render my tribute for the courage and the struggle for rights and access to justice. So, Priscilla, I'm moving fast, so I stick to my 10 minutes. But as you were for longer in the cause, I think this is the largest lawsuit seeking reparation seen in English justice. I understand the greatness of this lawsuit as a whole. I think we have many things, novel lawsuits on the path to the main lawsuit, surprising understandings, norms, adaptations, and opportunities that after the ADPF we can talk about opportunities for Brazilian law to be enhanced, so we can translate and update the proceedings in the many phases so society can understand this litigation not as a threat but as a way of access to justice for reparation. also greet my fellow countrymen, especially the lawyers, women and men, public defenders that since 2015 at some positions, public defenders here with us that at some position was in the resistance of this long administrative judicial lawsuit to make justice reach the affected one, and also the opinions of ADPF mentioned and in which I was involved, mainly greet here the victims and their representatives. We know Brazilian justice deals with the case and files actions and looks for paths within the legislation and the justice system to repair these serious consequences in each case and tries to have their own jurisdictions, states and unions. According to newspapers, he received daily information that we have agreements to be done, announced, etc. Well, I know most of us here don't know the details of the agreements, and it seems that maybe at least as method, they violate participation principles as well as participation of municipalities in some cases, even with consent, is through the state and their own institution, even with the slow ongoing. The things are moving forward. Another thing is the seek for justice that we stand for, and that here we stand for. And here I want to publicly add to these efforts to provide a response for the many ones who seek their rights. And I found out about the case, but not in detail. And in this phase, I come in the ADPF. I came across, I'd say, two races against time. On one hand, the eminence of the beginning of the English lawsuit with a date established. We have the countdown, and then a marathon, indisguisable marathon. I was talking about. So the lawsuits proceed in England and are able to struggle against the invisualization of the struggle, against national jurisdiction, the principles, the unchangeable constitutional laws, against the Brazilian Bar Association, and even the Supreme Court of Brazil, even if it's against victims and their legitimate representatives. I also came against an IDPF that seeks for a declaration of unconstitutionality in the Supreme Court on behalf of the municipalities of lawsuits in foreign jurisdictions, as well as the act followed to the annulment of the act, turned to the formalization of lawsuits abroad. The interested parties use a constitutional action arguing fundamental providence of our Constitution, precepts of our Constitution are violated. This can create anxiety when we think in reparation. The population doesn't even know about their rights, have no access to justice, have difficulties in imagining an international jurisdiction. But when we come closer to the case and understand everything that happened since 2015, the treatment provided to the affected, as well said by Tom a while ago, we came across a regretful procedure, misled proceedings recognized by justice itself. And I mentioned the lawsuit in the Fourth Civil Court and Belo Horizonte Court. This brings us to a way of looking for justice without interfering the ongoing negotiation processes or proceedings. And this should be a layer, a path, and eventually an exit. All that gives more reason to municipalities that seek for reparation when, how, and where it's possible, using their competences as a standing part in the action and fulfillment of a right. This justifies an additional path to the reparation lawsuit, not as renouncing states' jurisdiction and not forgetting our justice institution, but we must perform better justice when our land, our peoples, indigenous people, Quilombola peoples, our working population facing the exploitation of mining activities, and they are activities that are extractivist, do exploitation, and the Fundão Dam situation doesn't return the figures to Brazil, the profits, and all these are terrible actions against Brazilian population, against the Brazilian state. to talk about submission of Brazil to foreign sovereignty open the principle of jurisdiction and immunity is a huge distortion to the Municipal Proceedings Act that is not a diplomatic act, as well said by the representative of Cardozo. It's not confused with international politics, as mentioned by our dear opinion issuer Mazzoli. Nothing like that. It's a proceeding seeking reparation for victims affected in their territories to seek reparation for the population directly impacted. I who work with international law, and sorry, she's speaking very, very fast. It's very hard to translate. It's a fact that not even sovereign states can talk about immunity of jurisdiction, what Dr. José Eduardo mentioned regarding the major rights violation rules, universal rules, when imperative and responsibilities are at stake, private responsibilities, and moving towards closure. International public law explores the issue in many cases, and Brazil is a signatory of numberless conventions that adhere to the prevalence of human rights over internal law in specific cases of violation of rights, and was dealt with by the Supreme Court. We could say the Brazilian court, through its institutions and considering international commitments, should be whatever institutions add to the effort of access to English jurisdiction instead of reducing with limited arguments of sovereignty. Even less so we can talk about immunity of jurisdictions when they're private companies. Well, such argument would be effectively a shield to protect the companies of any damages and give them exploitation rights and with damage of human rights. And this has never been discussed in such a magnitude. The possibility of accessing foreign jurisdiction in a foreign court without international pending cases, without state jurisdiction. But on the other hand, as the municipalities claim, and representative of CODI 12 and ADPF add a layer of prevention protection, adding foreign jurisdiction where the headquarters of BHPs and the reasons for the municipalities, if there are enough reasons for municipalities, they are lacking for IBRAM. There is no legitimacy from IBRAM that argues constitutional violation, failure to comply with fundamental precept and all these excuses in evoking principles of maximum constitutional representation, elements of state-like sovereignty limited to their own interests and interests of representatives in mining and others. It's impacting, it's shocking. I need to say this, Eduardo Cardozo, to know the movement of the Institute was not a natural act. It had ambitious pretensions and it was driven as documented in the ADPF lawsuit by interest of the mining companies involved in the environmental catastrophe. The documents of the minute were examined by English justice and are at disposal of Brazilian justice system with many legal issues, and including excess of interest. BHP, I'll mention the company. I give myself this right here as reported in the representations of Abitcuri, alleges legitimacy to be a standing party in the lawsuit when IBRAM received an amount, so the lawsuits would be filed in the Supreme Court, and IBRAM, imagining limits to its legitimacy, evokes Supreme Court situations and situations that gave voice to a PB CONAC, the LGBTQI and the legitimated parties. Sorry, people, this is very, very hard. She's rushing. Comparing these issues to access to justice. I had many more things to do. I'll mention only two, but regarding a kind of random action of desperate measures in this race for before the Supreme Court, the Bar Association's Ethics Committee, with the goal of compromising legitimacy of the initiative of the English state and its representatives, the English law firm and its lawyer representatives in Brazil to create an image that they are extraterritorial predators regarding Brazilian interest. Even the distortion of the concept of lawfare was used as a form of delegitimacy against the defenders, and what we see is the other way around. We could talk about SLAPs, the strategic actions against public participation in this case, uh, lawsuits to silence the critics and the defenders. So doubtlessly, and I want to thank you for the opportunity of being able to say this because I was convinced by the case, and I'm very comfortable in the position that I'm mentioning. We are before an intimidation process. Once again, I think we have to reflect in Brazil, and Brazil must pay attention to what's going on. We have a major opportunity to add efforts for the victims of the largest environmental catastrophe the country has had. Thank you very much. Can I? Well, good morning, everyone. Ladies and gentlemen, it's a pleasure and a huge joy to be here this morning. I'd like to thank Tom for the invitation, Minister Eduardo Cardozo, my friend Carol Prone, and thank the law firm and also the Brazilian partners. This, especially this hiring, so I could issue my opinion at the Supreme Court to try to clarify the issue. I worked for 25 years with international public law, 20 books published. I was honored to participate in this lawsuit to try to clarify these points I'd like to bring here in the time I have, which are the points taken in this ADPF, some mentioned by the minister, by Carol, and then let's try to clarify this case once and for all. First, try to say it's a huge legal absurd, and the argument they use is that there is an immunity of jurisdiction that the municipality is not observing. Where have we seen immunity of jurisdiction on the other way around? I have immunity to not be a beneficiary abroad. An immunity of jurisdiction is a benefit the state provides, or the state has. It's involved causes with international relations. When a state is demanded in foreign jurisdiction, when Charles Menezes was murdered in the underground in London, that you can't sue in the interior of Minas Gerais state. They have to go. That's what's immunity of jurisdiction. It's a protection. It's not good when a national subnational entity is a claimant. The claimant can't be a defendant. There's no other way around jurisdiction. This is one of the most absurd arguments I can have in a cruel lawsuit this way, using the theory of jurisdiction immunity. Apart from that, according to our Supreme Court, there's no jurisdiction immunity in labor causes, the famous Giannini cause 1989. And look, there, it's an act of hiring by embassies, by diplomatic accredited parties. So the Supreme Court ended the immunity jurisdiction cases for acts not involving the procedure of international affairs. If you have some time, I can explain this better. What does it mean to maintain relations within foreign states? To file lawsuits in foreign jurisdictions is not maintaining relations with foreign states. If maintaining relations with foreign states says Article 22(1), it's up to the federal government to maintain relationships with foreign states and participate in international organizations. But the federal government doesn't celebrate treaties. The one celebrating is the president of the republic. In tax issues, it's forbidden to the federal government to exempt taxes. It's not the Federative Republic of the Brazil to exempt local tax of merchandise that comes in from the south. That was ruled by the Supreme Court. The Union is a subnational entity. The Federative Republic of Brazil has the federal government, states, and municipalities. The Union only has the very limited competence of maintaining relations with foreign states, and that involves diplomatic representatives, participate in international orders and themes that involve international affairs with other states. And in many issues, the federal government doesn't even have competence to celebrate treaties. That's the chief of the executive branch. It's not the federal government. And the National Congress has to subscribe. This is the Federal Republic of Brazil, which our federal government is one of the entities. So it's a very limited competence, and there's no providence saying the participation in foreign lawsuits has No reason to be. A most recent case in the Supreme Court, the Shangri-La case, the jurisdiction immunity in terms of human rights, comes to say there's no immunity for violation of human rights. If there's no immunity for violation of human rights, we don't even talk about immunity of jurisdiction in a private case. Apart from that, see these opinions that is our baseline for the ADPF. The opinions that support the ADPF come with a thesis in the sense that it would be a kind of maintenance of international relationship to file a lawsuit abroad. The thesis that the target is back there. We throw the arrow and it hits the target. It's built from here to there. The target can't be in the blank, and then you bring the blank to the arrow. If I qualify this theme as maintenance of keeping international relations, the private parties can't file lawsuits abroad. If filing lawsuits abroad by a subnational entity is maintaining international affairs, international private law is ended, doesn't exist anymore as a discipline. It makes no sense. All acts that don't involve state cases are absolutely possible of being filed abroad by states, by federal states, by municipalities, inclusively by the federal district. The city of São Paulo has a secretariat of international affairs. This would stop all the Brazilian municipalities in terms of international affairs. Minister, an argument that comes, and that really shocked me, maybe without false modesty. I was the one that most studied Article 52.5 in Brazil. It was part of my thesis, and all comments from Saraiva, big editors in Brazil, has my comments, and 52.5 says it's up to the federal summit to authorize foreign operations of financial nature from the federal district and states and municipalities. So receive indemnization abroad was not financial operation. I studied all the minutes of the Constitutional Assembly, all financial. This is regulating the national balance and financial operations where you require financial aid to foreign banks or consortium of private banks, or notably the International Monetary Fund through a letter of intention. So let's test it. If filing a lawsuit abroad and receiving money abroad is a financial foreign operation, all the internal operations are financial internal operations. And see the absurd the knot they try to tie. If it depends on authorization of the federal government and the Senate, first you authorize the operation by the Senate, then you go to the federal government. There's a double authorization. That's never going to work. This thesis that it depends on authorization of the federal government and violates Brazilian sovereignty has no sense at all. To violate sovereignty the other way around. Have you seen that in international law books? I'm sovereign because I'm achieved success in a foreign lawsuit, and I have private causes, private lawsuit against private companies. There's no international affairs in that, no governmental affairs. You can check all literature, what maintaining relations with international institutions that is signing agreements, international agreements, participating in international associations. So the thesis, Paulo Valério, can accreditate a diplomatic representative in Brasilia? No, because that's international relations. Can I participate in the UN as a natural person? No, that's maintaining international relations. I can file a lawsuit if I cross the border of Brazil and go to Uruguay and fall, and I'm run over by a car and file a lawsuit. Yes, I can. That's not international affairs. All a private party can do, the municipality can also do, because that classical difference, that small talk difference was forgotten in the pages of the laws, international law books, the difference between empire acts and management acts, or governmental acts and management acts. For the sake of God, that doesn't fall into international law rules in any way. That is fully legitimate, plainly valid. And if there is really a fundamental precepts violated. It's not the mining case, mining companies case. The violated laws is of the wanting populations that look up for indemnization against the social and environmental catastrophes in foreign courts, like the breach of the dam in Mariana and Brumadinho. I have no fear of saying that while as a professional that dedicates his life to international public and private law for 25 years, I have never read such an outrage talking about jurisdiction immunity the other way around, talk about sovereignty the way around, and saying the federal government has to represent municipalities in private lawsuits filed against legal persons of private nature abroad. So I wish dearly, Minister Carlton, that the Supreme Court takes this into consideration and clarifies this uh, issue once and for all, because as Minister Cardozo said, what's at stake is a human rights issue. What's at stake here is an issue that Brazil would have to help, to aid in. Brazil would have to help these people to look for these lawsuits abroad and to close really an issue that left me even, I didn't want to believe. Saying a lawsuit abroad would bring harm because it's in English language and thus the control national control institutions, there's no legal translation. The national control institutions wouldn't be able to inspect this lawsuit, and this would make it hard to for the public prosecution office to act. I've never seen in my whole career, my whole life, such large such fertile imagination. So thank you very much. I thank you all.
We have reserved a time for questions and answers, but due to organization of the timetables for the panels, we only will have one question now. Hello, good morning. I think I'll stand up. Sorry. Thank you for the opportunity of for being here in this event, an event that enriches us in relation to knowledge. And as was said, there is here we do not have a competition between the Brazilian law and the British law. And as Valerio Mazzuoli has said very well in his works, the human rights should be respected everywhere in the world. And if they're not respected, there should be redress, regardless of the location. It is no secret for anyone that IBRAM, within this attempt of taking away the legitimacy of municipalities in these lawsuits before other countries in international law, has filed for the Supreme Federal Court this attempt of removing the legitimacy of the municipalities. I'd like to know from you how you perceive this movement of IBRAM, and also which would be the consequences of this situation in regards to the relationship of municipalities with other countries and other international organizations, which would be the consequences for the Brazilian municipalities. Thank you. Without a loss to my colleagues who have mentioned this, but there are two things in your question that should be addressed and addressed once more. The first one is that IBRAM, the Brazilian Institute of Mining, is acting due to a request and with the support of BHP. IBRAM, and I sometimes kid about that, I said IBRAM because they're acting on behalf of BHP to defend national sovereignty. That by itself shows the the lack of honesty behind that. They received 6 million reais to land their constitutional legitimacy to serve interest of a mining company which is not even Brazilian. And what do they wish? They wish something obvious, not to pay. But as a collateral effect, they are hitting municipalities, and not only the municipalities, but the states as well. And if the federal government was the only one that could work with that, and it is not, but then the states would be affected as well. So all entities involved will be affected by their international affairs. They have nothing to do with the concept of sovereignty that they are radicalizing, and do not radicalize that to send profits abroad. At the bottom of the matter, this is egregious. And the professor has mentioned there is no legal thesis that supports that. It is not possible that a municipality and a state cannot do what a natural person or a legal person could do. This is unfeasible. This is an authoritarian conception and legally wrong. When I began working, I was hired as a administrative law consultant to work in my area of legal education. And the first question that came up was the mechanism of the Constitution that refers to the credit operations makes municipal lawsuits impossible abroad. What does one thing has to do with the other? This makes no sense. And my answer, I didn't even need to look it up. It was something obvious. Obviously, it makes no sense. What does one thing has to do with the other? Credit operations abroad, nothing to do with anything. Those are theses that not only are they wrong, but also they have a authoritarian bias, which is deep, and this affects municipalities. Many municipalities, as was said here, have international relations sectors. They do cooperation agreements. So just imagine in a government, and God rid us of this, but in an authoritative government, let's say that we had an authoritative government in Brazil, and then the municipality would not receive funds to find damages against the environment because they cannot establish agreements. And where will we get then? This would be a disaster for municipalities because they will be strongly impacted, not only for eventual lawsuits that they could enter abroad, but also the possibility of entering relations that any natural person could do or could enter. The same thing will happen with the states. So it is a disastrous situation, which in much overcomes the discussion of the case of Mariana from my standpoint. I don't know whether the governors are aware of this, whether other municipalities, and not only the ones that are effectively related to the Mariana's lawsuit, are aware of this, but I honestly say if I was a governor of a state or a mayor, particularly after the statement that the federal government issued, I would enter into this process to say, do not limit my freedom of action. Because what I want to do is what any private citizen does. Thank you. We thank all of you for your participation, and now we're going to open the second panel.
Segundo painel, gostaria
Part of the second panel, I would like to invite Ana Carolina Salomão, Antônio Carlos Cacai, Guilherme Setoguti, and Tomás Jatobá. We are still waiting for Mr. Kakai.
Ana Carolina.
Ana Carolina was already introduced earlier on. Kakai is a lawyer specialist in contentious law and a legal advisor. Guilherme Setoguti is a partner at Monteiro de Castro, Seguti advogado, professor at Insper, president of the Brazilian Association of Special Situations in Litigation Finance, doctor, a master, and with a degree from the University of São Paulo. Tomás Jatobá is the partner at Vinci SPS and a co-founding partner of SPS Capital, was a leader in the offshore actions in Mitigi Pastoral. He has a degree of law in the University of São Paulo. Good morning. We have an interesting and tough task after this first panel. We need to maintain the level and maintain everyone's interest. Before passing the floor to my colleagues and to our esteemed Kakai for their expositions, I wanted to explain and to talk a little bit about the topic of the panel. I'm sorry, I think it is the next slide, but the name of the second panel is Davi and Goliath, the funding of litigation and access to justice. It is a biblical name, and I wanted to explain a little bit about this name. It is also very rare for us to see people talking about the funding and access to justice and social problems in the same panel. But it is very important for us to mention this topic to demystify some situations. We, as loyalists, sociologists, politicians, journalists, all of us here today, we cannot forget that access to justice is not equal. It is not free to all. It is not possible to all. And amongst the several manners of acceding to justice, there are barriers to that access. And that is what we're going to talk about today. It is not possible to all Brazilian, British, Norwegian, African citizens to accept justice freely. And by access to justice, I mean to work with law so that the rights are heard and executed. I particularly see that there are three preeminent barriers to the access to justice. The first one being an information barrier, especially when we're talking about big environmental disasters. The parties affected by those disasters don't necessarily have all of the information necessary um, to bring the causation, to assess the extension of damage, and to actually employ the law to seek for redress. Another barrier that we have is the institutional barrier. Not in all jurisdiction is it possible that parties individually or collectively are able to access justice. In Brazil, we can talk about how small or insufficient the mechanism of public civil action is, so that collegiate groups affected by environmental disaster can collectively try to use justice. But there is a third barrier, which in my opinion is more important than the others, because it helps overcome the previous barriers, which is the financial one, particularly when we are considering the disparity of resources between one party and the other. And there you can see the name David and Goliath. And the access to financial resources or the lack of thereof is a barrier to reach justice, and this barrier can become impossible to overcome when one party has the resources and the other does not. This is what we're going to approach today, and it is important for us to know, not only within this room, but outside it as well, for us to be able to connect these two subjects. Who is interested that one of the parties has financial resources and therefore has more access, more institutional access, and has a better condition of gathering information than the other party? To who is interested that the inequalities in the law are maintained, social inequalities that are even more highlighted by financial inequalities? We should consider those matters. And with that, I pass the floor to dear Kakai. Well, Anna, on her behalf, I salute all of my dear friends here today. It is interesting to note that regularly the seminar, and I was reflecting about that when Anna was speaking, I always think about what I'm going to say when I'm listening my colleagues speak. We, the first panel was spectacular, and we could deepen on that. This is a bad problem, but it is necessary for us to have this second moment to explain why we are here, why there is funding for causes, for us to explain why we want to grant access to people to justice. And here we have an extremely authoritative bias, and even a cruel one, I should say, because we are dealing with mining companies that do not need funding. They are making the funding. And they were daring enough to give 6 million reais to IBAN, funding an DPF in the Supreme Federal Court to stop municipalities from being able to access the jurisdiction. It's interesting that you've mentioned the states with two or three states that we entered into contact with. They already accepted it, and they're entering into amicus curiae because this thesis is completely absurd. And I appreciated your words, but we need to move further. And I don't know if Fernando has left or whether he's here, but my greatest sadness in this lawsuit, and when I'm talking about class action, I was the first actor of ADC 43 of the presumption of innocence that reached numberless people. There was no need of funding of an ADC in the Supreme Federal Court, where we entered into at a first moment worried only about the people arrested in the prison system in Brazil. And with the evolution of that, there was a victory in that lawsuit that allowed the freedom of President Lula. But we had some questions, and then we had more ADCs. Otherwise, the movement would not have reached the level it did. We would never win in the Federal Supreme Court if there was not that amount of movements. But there we did not need funding. There was a direct action of inconstitutionality for the Federal Supreme Court that would reach a huge amount of people here. And with the hypothesis of funding, your work would be impossible. And this is a work that has an incredible value. And I wanted to mention here something that really made me feel emotional, which is the standpoint of the Brazilian government in this agreement that is being conducted, where 600,000 people or 700,000 people are not in the table of discussion. I wrote an article about that. The people impacted are not present. How can we talk about funding when the mining companies can, with the force of their money and their power, to talk directly with the federal government alongside the two states that say they are being damaged by that, and they are, when they are not in the discussion of that, the people impacted. And this is a scandalous. This is a scandal that should be taken to the federal government. When these people are taken away from the table, this authoritative matter is being enforced. We have a federal government which is popular, directly connected with the most humble people in the society, and they cannot exclude from the table these people in a shameful way. These people should be in the conversation. Priscilla knows this. I talked to the government of Bahia, which is also impacted, and they are a popular government. And you do not need to agree with me, but it is more popular than the government of the state of Minas and the state of Espírito Santo. And when we're talking about with the state of Bahia, well, they say, I have a right to be here. There are 5 municipalities under litigation. But I do not want to sit in this table without the people truly impacted, because this is the scandal that is undergoing now. They are what they did with the law firm of Felipe in this lawsuit in the OAB is something that shows their economic power. They hired big law firms and lobbyists in order to stop the Brazilian law firm to act. They have a huge economic power to hire whichever law firm they want. And I'm not criticizing the law firms that entered into that contract or not. I work in litigation and I'm aware that this is their right. But they evidently entered into lawfare, trying to make the law firm do that which they do daily. And José Eduardo said this very well, perhaps with a more elegant wording, because the law firms are not used to stepping on the mud of seeing the pain of the poorest people, of seeing those that actually have the rights of quilombola people. And I've begun friends with two quilombola people, and they're not sitting on the table. This is the economic disparity, which you could say is predatory, and the action that you are taking with a lot of dignity. This is something to help them access the judiciary branch. The judiciary branch is distant, is expensive, is reactionary, it's misogynistic, and we need to have this type of perspective in order to make a basic question. Why do they want to use the law firm that is doing this work with even the possibility of cassating the right of working as lawyers of the law firm, because they know that they are not correct and they do not want the dimension or the depth of the discussion that is necessary. And they took away from the discussion the ones that are the actual victims, the actual impacted ones. So a lot is at stake here. In this moment where very briefly we are seeing being announced and propagated by everyone that which would be a big agreement, a big one, the 600,000 people there. And of course, beyond making agreement close to 100 million, this is a shameful agreement. If they can, they're only going to pay $100 billion because they know they owe 500 billion. Within the legal field without this passion, there should be a discussion to analyze the data that you have, or to hire companies to see what was the actual impact. And I'm going to do something which for me, and I had the opportunity of saying that to more than one person in the government, this is something which blows me away, which is proposing 30, 40,000 for each one of the person that has adhered to that. And people will do that because they haven't received anything for 9 years. They lost the river, they lost their works, their way of life. And once they have accepted the agreement here, they will let go of the lawsuit abroad. This is something that, from my point of view, takes away their legitimacy. And so I say, it is very bad for us to go to the second phase of the debate. We should have remained at the first one, and there would be no doubt you're doing the right thing. When you're doing financing without which it would be impossible to reach the 600,000 people. And why do they want to stop the funding? Because they do not want to sit with the 600,000 people at the table. They do not want to discuss with them. For them, it is comfortable to discuss only with the Supreme Court theses that, even though absurd, will be supported by a good part of the panel. The AGU has already mentioned the matter of sovereignty. And I have been working at the Federal Supreme Court for more than 40 years. And there was the thesis of legitimacy of IBRAM, which is a good one, but the Supreme Court would only talk about that if they did not want to try it by the merits. And so we need to face this matter. And certainly that's why they want to take away from the table a discussion that in thesis would bring some awareness to the government, not to mining companies. Mining companies do not care about that. They are funding, and as José Eduardo has said, IBRAM brought 6 million reais and they're financing a thesis that should not be under consideration by the federal court, Supreme Court. And they're trying to bring an appearance of a technical discussion, since it is not a technical discussion. This discussion necessarily considers that which 600,000 people impacted have suffered, be those riparian populations, the Quilombola populations, and all the other municipalities who were impacted, which were impacted. This is a false, small discussion. So I want to give congratulations on all of you for your work in making this funding into the financiers as well, because what we are discussing here is the access to justice. And what they want to do is stop people from being able to access justice. And to their sadness, and to our sadness as well, they were able in the agreement to stop the access, not to justice, that we are saying is the judiciary branch in a strict sense. But they're stopping the access in the agreement that is being proposed, and they're trying to choke the access to justice. I have an extreme joy of representing those that actually have a right that should be heard not only by the Federal Supreme Court, but also in the negotiation tables. It is a shame that a popular government is a part of an agreement such as this one without hearing the people that are the actual victims, those that have the legitimacy to conduct this agreement. Regrettably, we need to try to do that so that the people participating in this discussion should be expanded. And the state of Bahia should at least be present, if not all of those people. So there is legitimacy in the discussion. Thank you very much. Wow, after this amazing discussion of Kakai, which brings to the table the reasons why it's necessary, it's very important for us to get our arms to try to represent the groups impacted, particularly in the disaster of Marianas, but in other causes of the law firm as well. I'm going to explain how the litigation funding works in our case, for those of you who do not know, and I'll have a debate with Tomás Jatobá and with Guilherme Setoguti. Kakai is absolutely invited as well to enter into this debate. So our law firm works a little differently than those law firms that are attacking us today before the bar. We do not charge fees. We work alongside our clients. We carry the fees of the action until the final result. Of course, for this to be possible, it is necessary to use funding. As well as in any other financial activity, we should say that there is an access to unending funding by mining companies, by metal workers. They're able to open capital. They're able to go to banks. They can go to the capital markets, to the financial market to ask for a loan. But for riparian communities, for Quilombola communities, for indigenous communities, those affected in general, there is no line of credit to access justice. There's not even an institutional mechanism through which, in Brazil, they're able to join themselves in a private, collective manner to go to the judiciary. So that is why the law firm raised funds at its own expense, at their own risk. Our clients have no legal or financial risk in that sense to raise the necessary amount to fight this war, which is being waged against the mining companies. It's important to connect these ideas with Kakai's exposition, because this is becoming a war full of dirty battles. A battle which would be to join all of our clients and go directly to the courts in London and follow the proceedings that are British, but they're opening other fronts. They go after the OAB, they finance the ADPF, they go after the press, the publicity, social media, and all of this has a huge cost. If not with one of the parties funding that, where would those amounts come from? All of the economic activities are funded by third parties, including the law firms. Law firms themselves, the big Brazilian law firms and throughout the world as well, are funded, whether be it by banks, party partners, or clients that have a lot of money in their pockets and they're able to pay up front at times. And this is not the reality of our clients. And that's why we're not going to stop servicing them. We should be creative in the manners with which we will be able to attain those resources. And in discussion that no one better than Guilherme Setoguti, a big scholar that talks about litigation funding in Brazil, the president of the Brazilian Association of Litigation Funding. Guilherme, tell me, how do you perceive this relationship or this dichotomy between the access to justice and the litigation funding? Thank you, Anna. Good morning, ladies and gentlemen. It is a huge honor and a pleasure being a part of this event. And we are conducting a necessary debate. It is important for us to be here. And I wanted to thank Anna, Tom, and all of the other colleagues from the office, the law firm, for this invitation and say that our work used to be difficult, but after this first panel, after Kakai's speech, well, Jatobá will have a hard time, but we'll try to do our best. As Anna said, as Kakai said, there are a number of barriers in accessing justice. To conduct a lawsuit costs money, as anything in life. So, firstly, there is an economic barrier, a financial barrier for litigation. You need to hire a good lawyer, you need to have a good technical assistant, you need to pay the legal fees, you need to pay the fees of arbitration. If it is an arbitration dispute, you need a number of fees that are involved with litigation. And countless time, the impacted persons do not have those resources, as is the case of Mariana's. So, one of the first barriers that we face in accessing justice is exactly the economic financial barrier. This is something crystal clear. But there are other barriers that are also related to accessing justice. And funding tries to overcome those barriers in ways. Another barrier that we have is the information barrier, as Anna mentioned. Many times the victim involved or that incurred in damage is not even aware of their rights, or if they know that their rights were violated, they do not know the extension of that violation. They don't know whether the damage that they suffered will be able to be repaired by an agreement offering, let's say, 10, when they have a right to receive 150. And many times they have to settle for a bad agreement because they're not able to access information. So when you have a financier, they help to overcome the information barrier because the financier is someone who will pay someone who is a specialist, who will have advisors that are the best professionals, and they will help this victim of the damages to make a fair decision in their best interest. There is also a relationship barrier. Many times I've had clients in my law firm, rich families, but they are not within the big centers and they are not used to bringing lawsuits. Sometimes the party has a lot of money, but they don't know who is the best lawyer. Many times they'll hire a lawyer that is not defending their interests. So the financier, since they are a specialist entity in this market, they are able to say, well, for this case, let's hire Kakai. He is a well-known lawyer. He's the best person for this cause. Let's hire Minister José Eduardo Cardozo. So the financier, beyond being able to contribute with the funding, with the money, and also being able to access other spheres, they also help the party, the damaged parties by big disasters or by fraud. This happens as well, and we can talk about this, but they help these people assemble a team of specialists which will defend the rights of those persons correctly. So, to begin the conversation, to begin heating up our engines, I think that there is a clear connection between the access to justice and litigation funding. Many fundings of litigations, such as the one in Mariana, make this possible to take to the jurisdictional entity. So the funding is necessary to organize the interests and to make an adequate and fair defense of interests. So in answering your question objectively, I think that there is a very direct correlation between access to justice and the funding of those multi-individual interests, which should be, on the words of Professor Carlos Watanabe, molecularized. They need to be joined. so that they can be adequately defended. Imagine if each one of those persons impacted should enter an individual lawsuit. This would be impossible and they would never be able to achieve a fair compensation. Thank you very much, Setoguti. In continuing our conversation, I'm going to pass the floor back and forth, but I would like to call Tomás Jatobá to be a part of the debate. For those of you who do not know, Tomás is the founder of SPS, and he's the responsible person for the area of investment in litigation assets, and he is one of the investors in the Mariana case. I think it's also important for us to state how the process goes in this type of funding. I would like to ask Thomas the challenges and how this, I'm trying not to speak in English, but this assessment, this analysis in relation to whether they should fund or not. But I want to talk about the story of the Mariana case, because when we see in the press that the law firm has raised thousands and thousands of dollars and we had unlawful funds that are playing games with the rights of the impacted people. We do not imagine the story and what in fact happened. So it's important to tell you how that actually happened. So there were a number of rounds of investment in that case, which is actually a roller coaster. So if today we have a right in more or less 40 days to start a trial within the British courts to fight for the rights of our clients. This was not true, let's say, 5 years ago when we filed the action. This case was extinct without a judgment of merit in England. And so this was a decision confirmed by the second instance, but the law firm did not give up on fighting for the rights of our clients. But in order to do that, we needed to enter a receding action, annulment action. And the annulment actions are very rare in Brazil and also in England as well. And thanks to investors such as SPS and others that are here today, we were able to reverse the situation. And of course, this is not something easy. But Tomas, tell me, please, what do the investors in this type of case that is related to human rights and environmental rights, what are the specific complexities of those cases when you're considering the investment?
Well, first of all, good morning, everyone, ladies and gentlemen. Thank you for the opportunity of being here today, talking about this case, which is my preferred case in the portfolio, because as investment management and alternative assets, especially litigation assets, we see all kinds of lawsuits or requests for funding for the most diverse kinds of lawsuits. And the degree of conversion is very low. It's very hard for you to bring a case, especially at the stage Mariana's case was, and see that there was very good merit to in the case, and that beyond doing a good investment, because it's always good to remind we have no fear of saying we do that for money. We are a capitalist company living in a capitalist society, and that my fiduciary duty as a fund management is to create a profit for my investors. That is not a crime. I'm very happy to know my money and my activity in financing, that I hope anyhow is profitable, is being used to make it possible for over 700,000 victims should get access to reparation, and without our money, that wouldn't be possible. So the first filter we do, at least in Da Vinci, the question is, are you on the good side of the force? Are you in the good side of the force? Because we can have claims with merit. I can quote examples of cases of claims against pension funds. For the better they would be, the better the merit of the case would be, I would say I won't finance a fight that in the end of the story will take money from the retired parties, even if they acted in a wrongful way. In this case, this was the first filter that wasn't the easiest thing in the world to go by because you are struggling for victims that lost everything. They don't have access to any kind of funding, and through the money of our investors, we can make it possible for them to access one of the most expensive jurisdictions to litigate in, which is the English justice system. And another filter we uh, use is the stage of the proceedings. And when we joined the case, it was at the very beginning, very, very beginning. I remember till the day, the first talk with Ana Carolina and Tom, the law firm was still pretty small, and the presentations of the cases didn't have all that structure, events in Brasilia. And we looked to that, and I said, wait a minute, you have to know how to mine in the good sense. And as it was an initial phase, we had to do all the investment of hiring foreign lawyers that are very, very expensive. But what we saw was that I looked and thought, why are you standing for the fact that you can file a lawsuit in England regarding a fact that happened in Brazil? So we did all the investment in that case, and all the responses we got was that no, because of all the legal framework that is in action or is valid, the merit chances are high. Because the great challenge was jurisdiction in this case, because sincerely, there's no way of saying that BHP is not responsible for the damage that occurred. And they may even, it's an absurd thing to say it was an earthquake. Not even they believe in that. So we were able to go by all these phases, and even so, we had in the first degree of jurisdiction, they said it's colonialism to stop Brazilian municipalities to litigate abroad. Brazil of the shameless colonialism was the ruling of this first degree judge. They said you can live in your third world countries. It will be costly for our courts to analyze these cases. So it's the other way around, where we're using the resources of the English courts to sue an English company, as well mentioned by Tom. And anyhow, it's with huge joy we are here at the brink of the merit hearing, and they were welcome in the English system. You have many moments where you have to deposit the resource equivalent to the loss of the lawsuit beforehand. So it was very hard to set that around to turn the key on that, but we were able uh, to prove the obvious, which was to prove the responsibility of the companies for the damage caused. Thank you very much. Cacao, without putting you in a hard spot, I'll ask you. I know you have a story of struggle for social rights, and you stood for many clients, private and collectively, that were on the least favored side regarding economic power. But a simple question. Normally, the client that arrives to your law firm gets there, asks you, checks the fees, and is able to pay for them. And then a client that has enough financial resources can access, as well mentioned, office law firms like Almeida, Castro, da Turbaya, Monteiro, Setoguti, these famous law firms and chic law firms. But the truth is that it's harder for the other side, people who have no resources. But it's interesting what we're hearing from the press, that the funding of litigation can favor uh, pointless cases with no merit. And according to what Guilherme said and regarding what you said, Kakai, the funders do a very strong selection to choose the cases they got to bet their money and place their investors' money. And we can understand by what Thomas said that it's not an easy criterion. There are many faces, as he himself said. Would there be any sense, Guilherme? And then I'd like to hear Kaká about this also, saying that litigation funding can increase the number of meritless and meaningless lawsuits. This is an interesting question because in this debate about litigation funding in the whole world, there's an opinion that, look, litigation financing is bad for justice system of the country because it will overwhelm the judicial system with bad cases. But there are dozens of economic studies that show that it's exactly the other way around, that actually the funder, financer, as he's a professional of this kind of cause, he does a very thoughtful analysis, and there would be no economic reason or legal reason to put money like Tomas placed in the Mariana case for a bad cause, frivol lawsuit. They hire good office, they do analysis of the case, and these law firms will say the victim he really had their rights violated. They are entitled to receive compensation. That mining company, that oil company, that stockholder group, or that major company did accounting fraud, caused environmental disaster. So based on that analysis, the investor will say, really, Ana Carolina, I'm here, X thousand reais, X million reais, to file that lawsuit against this company and pay for good experts. So what these economic assessments show is that the other way, the it occurs contrarily. It's the other way around, as they say. We have a natural selection for good cases. These financiers filter the bad cases, cases with no merit, or frivolous lawsuits, as I mentioned, and they send it to the judiciary for arbitration, and they take actions that have merit involving victims that really had their rights violated and would be entitled to receive indemnization equivalent to what they really lost. So there are contrary opinions, but my view, and based in many economic and juridical studies done in Brazil and worldwide, show that in reality what happens is the contrary effect. Instead of stimulating frivolous lawsuits, you end up stimulating good lawsuits and giving voice to these good actions, making it possible for people to have access to justice in lawsuits that normally they wouldn't reach the judiciary because these people don't have any resources. So I think that's it. I am a true believer in that the effect is really that. But I'd like to hear to Kakai also. I think we are in the same tone because frivolous actually is the hiring of Ibran to file that ADPF lawsuit. So that is with a thesis that below ridiculous and with specific interest in claiming access to justice. So first, I'm very happy here because you've mentioned twice that I should be hired. So I'm here. So advocacy, within what you said, our advocacy is 40% pro bono. We're used to dealing with cases that have no economic involvement of the law firm. But I have a very large concern. Your explanation settles the matter. I think it's very good. Actually, you are market people. You only place money where there is not only a good chance to win, but it was very good that you mentioned it. There are causes that also have a baseline that you can commit to say judicial and social. We have to be careful with certain things. For example, certainly there's someone on the other hand recording our speeches. Tomorrow we can have headlines within what you said saying, we do that for money. which destroys the whole of the rest of your speech, and which is correct. That's why I've hit hard on our groups about the need of having being careful when we talk about against the agreement that's coming out at the beginning of October, criticizing the government for the absence of the people that were harmed sitting on the table. Actually, we have to be careful because if not, they will say we are against the agreement, that we have such a financial interest that we want to stop things going on. It's not that. It's because the agreement is being done without the victims sitting at the table. So I understand the presence of the finances with this technical look. Of course, you also must have, say, threshold, which would be a social threshold. That wouldn't be only by you. It's done by the law firm that is seeked. If the law firm wants to put all its strength to be able to represent 700,000 people harmed and 46 municipalities, it's because it's a social baseline that is extremely interesting because they include the Riverside people, the originary peoples, the Quilombolas peoples, the Maroon people. So it's the first analysis is done by the law firm that is contacted. But your explanation was necessary because it's not simply that issue of saying, no, they are law firms that are financing, trying to get profit at any cost. It's on the other way around. There's a necessary analysis to be done previously. You have to explain that very well. But we who work upon the cause have to be very, very careful, especially when we do specific criticism to the way in which by which this agreement is being held in a popular government. Shameful to me to have these people excluded. But it might seem also look how everything in life in cases like that have a risk. It's risky to be placed as predators that the lawyers are criticizing the absence of the excluded parties, seeming that actually we are more concerned with the financial side. But it's very good that you're caring for that. It's very good that the law firms have that concern. And I think that, yes, some people are terrified of talking about access to justice. The justice must keep on patrimonialist, extremely conservative, and for few. That's the goal. It's exactly that. Justice is not an oligopoly for people who can pay for it. And I always do a reflection of why these accidents happen always in the global south. It's always in a poor country. You don't see same things happening in BHP headquarters in Australia. You don't see these things happening. You don't see oil spills in the North Sea because there you have mechanisms of financing and of access to justice as a whole that multinational corporations know they will be held responsible. So they increase their standards of safety. There's a lot in litigation financing mentioning the doctrine of efficient breach, that the calculation you're going to do to uh, violate a contract or an obligation or fulfill it is from the standing point of the company or the contractor an economic calculation. So when you violate the law, it's cheaper and more, it's a larger advantage than fulfilling it. The companies will keep on violating these rules. So it's essential for the litigation financing market that large companies know that if they do any illegal act, there will be funds that will be available to take the cause and fight in equal conditions with the companies in any necessary jurisdiction. So today we learned that access to justice is not free to all. The barrier has information, institutions, financial barriers, and that these financial barriers protect the ones that harm rights already established, civil rights, penal rights and economic rights, and also environmental rights. We also learned that this is important not only to seek for justice for the victims affected by disaster, but by for all society. As Thomas mentioned, impunity only interests those that violate rights. Well, with this, I'd like to open for Q&A if there is any questions from our participants. Good morning, everyone. I'm Gabriel Alves. I'm a lawyer. I'm an attorney, young attorney. And my question is very simple, but I think it's interesting mainly for the listeners, people who are watching remotely. I'd like to know what is the benefit for the harmed one of filing lawsuits in their origin countries and not only in the countries the environmental crimes happen, like in Mariana. The value of the reparation would be more robust. I'll begin and then uh, I'll give it to Kakai. I can say yes. Effectively, the value will be more robust. That is empirical. Disconsider the English process. We can say that victims for 9 years since the disaster seek tirelessly for reparation for the damage, and they got nothing. The few ones that got something certainly that involves a value that is not even a tenth of the reparation true amount. I can say empirically the foreign lawsuit was what caused the companies and the Brazilian authorities, unfortunately, to pay attention to the disgrace that happened in the state of Mariana, the state of Mariana, the states of Bahia, Espírito Santo, and Belo Horizonte and Minas Gerais. It doesn't interest why victims went abroad. What interest is the key is if they have the right to do so, as Professor Maioli mentioned, any private party would have the right to recur to foreign justice systems if the damage was caused abroad and if the defendant is in that jurisdiction. Anyhow, if once the judicial system accepts ruling the case, and that's what happened, I think it was important, and I thank you for your question for us to reconfigure that kind of questioning because there's no pending lawsuit. Nothing stops these parts to recur to foreign justice. And I go beyond. If they would be two companies, two multinationals, or an investment bank and construction company that had done exactly the same situation of seeking for a foreign court, no one from the academia would rise against it. No Brazilian authority would rise against it. What is shocking for the privileged guys is that who's using these sophisticated legal instruments are the ones that normally are crippled from this access. Well, your question, your answer to it as the former governor of Brasilia would say is a two-edged knife. It has a huge risk because of what was mentioned in the interview, which is totally correct. It's part of the Brazilian judiciary began adopting a posture that it's a despise for Brazilian justice system to look for the English justice system. And that's absurd. We saw the president of the Supreme Court, whom I respect very much, to mention about the agreement that's about to come out, that it's important that it comes out and before there's a ruling in England. So Anna mentioned it very well. There is no counterpoint or people have the right to choose where they can act. So the jurisdiction was accepted there. It's against an English company, and mainly, of course, you have to have an analysis, and investors do that analysis of up to what figure this can get. There's a extremely unfavorable jurisprudence in Brazil against that. Of course, there are smaller values, but the core of the issue, and replied to very well. What is interesting is that they have the right to look for the English justice system. If it would be the large banks, we advocate by rule for powerful clients, doubtlessly. Marco Aurélio is here. He has the most powerful clients than mine, and clients that naturally will look for foreign jurisdiction, and that is not even gets to headlines when you put 600 people, Negroes, Quilombolas, originary peoples, riverside populations that have this, between quotes, privilege of hitting England. Why? Look how your question comprehends everything. Because there are financiers, there's no law firms in England that have this vision that is legal and humanitarian also. So we have to run an enormous risk when we discuss this specific issue. It's no privilege, absolutely. It's a right to be exercised. So when someone comes to my law firm and looks for my law firm for a given demand, I'm the one who chooses where I'm going to file the lawsuit. I'm the one who writes down the initial petition, and so this is an issue that's only between the lawyer and the citizen. And it's good to that you talked about this in detail because we have to really strip this naked. And look, I got to this cause yesterday, but I listened from many people interested in the government. There's this that there's a given despise for the Brazilian judiciary. If I say what I think about the Brazilian judiciary, I'm going to reinforce your opinion. So I'm not going to say anything. But what interests us is a simple answer. They have the right to look for the English judicial system. If you criticize them because they're exercising their rights, then we're having a huge setback. As to make a brief comment, I think your question is excellent, and there could be a panel to talk only about this. But as Kakai mentioned, this is a technical decision of the attorney and people caring for the cause to say, look, where is my client getting maximized chances of winning his cause? And we can choose another state in Brazil, another municipality, another country, or always looking to maximize reparation and chances of success. But if you think of another areas like corporate fraud, I don't want to quote company names, but there are many examples of Brazilian investors that suffered damage that other investors from other countries also suffered, and these investors from other countries, because they filed lawsuits in other countries, got an indemnization much sooner, and Brazilian investors got nothing exactly because they didn't have the possibility of accessing justice in another country. That shows that in given situations it would be a better advantage for a victim of fraud or a major environmental disaster to be able to access another jurisdiction once this jurisdiction has a relationship with a party. And in this case that exists because the uh, defendants have a relationship, have a domicile in the other country. Just remembering that if we are going after foreign justice, no one wants to play in the enemy field. So if you go to another country that's not yours to apply your law in a different country with people who don't understand your laws, it's because you effectively aren't being able to obtain fair and swift reparation in your country. And on the issue of financing, I keep thinking if we had in Brazil, we would be financing the victims one by one, filing one lawsuit by one. There would be people saying we would be capturing clients, promoting the overwhelming of the judiciary system in Brazil, which is already full of lawsuits, and we could be doing that. So we'll finance law firm that gathers everyone and files a lawsuit against others in other jurisdiction. And you can do that because you would be harming the Brazilian judiciary.
Thank you very much to the panelists and everyone as well. I close the second panel.
Aos integrantes.
I would like to invite the integrators of the third panel, Felipe Rota, Marco Aurélio de Carvalho, Gelvana Aparecida, e Wakre Wakrenaki. Felipe Rota is a partner of Pogust Goodhead and chairman of Hot Advocacy. He has a degree by the University of São Paulo, master in environmental law by Queen Mary University of London. Marco Aurélio de Carvalho is a specialized lawyer in public law, a member and integrator of the group Prerogatives, and founding partner of the Brazilian Association of Legalists by Democracy. He has a degree of law by PUC São Paulo. He is a lawyer, a partner, and founder of Marco Aurélio de Carvalho uh, law firm. Gelvana Brasileira Silva is a technician of work safety. She lives in Moro Branco, Gerais. She was born in Ponte Nova, Minas Gerais. She lived in Marianas at the time of the collapse of the Fundão Dam. Her son, Thiago Damascenes dos Santos, who was 9 years old then, is one of the 10 fatal victims of the collapse. Today, Giovanna is an active voice in searching justice for Thiago and all the other people affected by the disaster of Mariana. Wakra Krenak is a biologist, a filmmaker, and one of the leaderships of the Krenak village. She lives in the municipality of Resplendor. She is a mother of an atypical child and one of the active voices in seeking for reparations for the indigenous peoples affected by the collapse of the Fundão Dam. Good morning, ladies and gentlemen. Thank you for being here today at our seminar. I wanted to talk with you and to thank Giovanna for her presence and Wakrewa as well. They are making their time available so that we can once more share the challenges and the difficulties that they have been facing in the pursuit of justice after the crime of the Marianas. It is not easy to relive traumas of a very difficult event in their lives. But as we're going to debate today, those traumas are essential to be brought up by the voices of those impacted. This has to be said by their voices, and the center of attention needs to be on them. Perhaps we have a difficult panel right after a minister and a lawyer such as Kakai, but I believe that today we have the most important and impactful panel of the day because today we can count on the voices of those actually impacted, and they will be able to speak from their perspective what happened and what has been happening in this struggle for justice. A justice which is marked by environmental racism, where the voice of the traditional communities, indigenous communities, and Quilombola communities are silenced, and they're not able to sit on the negotiation tables. A voice, an instance where women's voices are not heard. Here we'll have two mothers debating how hard it is being a woman, a mother fighting for justice on the face of this crime that the companies Vale, BHP, and Samarco have caused. Therefore, I do not want to spend a lot of time because we should actually use the time with the people that matter today so that they can speak on their lives, on how those affected women, mothers have been suffering and have been trying to find justice in this journey over the last 9 years after the crime in Mariana. And now I'm going to pass the floor to Giovanna. Good morning, everyone. First of all, I want to thank you once again for being here representing the 20 families of the peoples that were taken by this barbaric crime, and have still not been punished, and we're still fighting, and we won't lose hope. My son was 7. He had his whole life ahead of him. He was simply taken from me, and I didn't have a chance to say goodbye. We had 7 days of fight, of hope, 7 sleepless nights, 7 days without food, so that by the end, I could not see my son even for 5 minutes. And it was a closed casket burial. He was found 100 kilometers away. He was dragged for 100 kilometers. He was with his grandmother at the time. He had a lot of faith in God and he asked Jesus to save him. I'm faithful that Jesus saved him at the time and did not let him suffer. But the feeling that was left with me is a feeling of suffering. Today, I'm looking for justice. not only for him, but for the 19 victims that are gone and for the 600,000 people that were directly affected. Because today there are people that have brought lawsuits 9 years ago, and this lawsuit is stopped. It only had one hearing, and now it's stopped here in Brasilia. We have mothers who today their daughters always ask, Mom, where's dad? And what is the answer that they can give them? He was murdered by Vale. Today I have two children, one 4 and one 5 years old. Sadly, I don't want to show them my pain. It is not because I have two children that I will forget my son. Every time I come to an event, I talk to my son. I tell him, son, your sisters are still here, but today is your day. Not only your day, but the day of all of the people that are gone. Only God can give us strength for this. But I'm a very Catholic person. I have a lot of faith. And if I'm here, I believe that it is because of God. Because when a mother loses her son, this is an immeasurable pain. It is unexplainable. When I look at it, I think, well, it was just me and my son, no one else. I worked and I lived for him. And today, this piece of me was brutally ripped off. And once more, I thank Pogust. Because before that, we were never called to be heard anywhere. They never knocked at our door asking, do you need psychological assistance? How are you doing? Sadly, we are just the 19 victims. There it is. This is a full stop that they put there. We are not heard. We have no rights. We have no voice. We're simply, oh, the ones that were impacted. And today, Bento Rodrigues has become exactly how he wished to be. Today, Bento is a jaker full of water. Today, for you to enter Bento, you have to be followed by several guards. And they ask what you're doing there. If you're going to record something, they won't let you in. They'll stop you. Today, the new Bento Rodrigues is practically consists of houses, of mansions. But those mansions now will be all of the responsibility of Renova, and after 5 years, they can't even buy the paint on the house's wall. And why is that? Because those are humble people. They are people that do not know the price of that paint. The first impact is, wow, that house, I'm going to live at that house. That hurt, the pain that they had, they set aside because they instantly think that the house is beautiful. And today, Manaus has a real estate sector that is putting the houses on sale. And we wonder, for whom did we make Novo Banco? For the partners of Samarco, for the manager of Samarco, the manager of Vale, because they have the means to maintain the houses, but the humble people from Bento, they cannot. So there are countless factors involved. We don't have a voice, we don't have any involvement, and I thank you once more for having this opportunity, since Renova does not know I exist until now, and today I'm working with someone who worked at Renova, and they told me, Gelvana, I left because I've never saw a single person who lost their family. I wanted to get to know someone. I went in there to make justice, to help people that were affected, but I saw that that was not what was going on. It was just money laundering. How great it was meeting you, she told me. How great it was meeting you. So, not all of the people there are people that want to harm. Some of those people that thought Renova would be a good company, a company that would grant the assistance that Bento needed, that the victims needed. Everything that the media says is a lie. All you have to do is go there to see how the situation is. There are houses, there are mansions that are falling apart. The bathroom is falling apart. The wiring of the house went on fire. Is it because they don't know how to take care of it, or is it because they weren't trained to even enter houses such as those ones? Thank you, Giovanna. Well, this is a very sensitive topic. Thank you for sharing with us. Now I pass the floor to Akrawakrenak, and we can touch upon the matter of the difficulty of an indigenous mother, the matter of indigenous culture, how it was affected, and how the support of the government and the companies has been, and how they have approached the matter of the damages of the traditional communities. Hello, everyone. My people usually says "wehe," and this is how we say good morning, good afternoon. As Felipe said, my name is Wakre Wapenaki. I am a female leadership from my people. I'm 33 years old. I'm a mother of three children, two of which are autistic children. And it is not difficult or even easy to talk about my people. There is a sentence of Stella Shakiaba where she says, if Brazil began with us, why should we be the last? And I'm going to add something. Why should we be the last ones to be heard? Why? If I, as well as Giovanna, lost my son, why will we be the last ones heard? Here we had a number of lawyers, ministers, people that are well spoken, that can express themselves very well, that say complex words. But living my reality is way harder, it's way more complex. To be within my territory, to have the river running by, and not being able to touch that which your mother, your father, your grandfather taught you that is sacred is absurd. It's absurd to talk about human rights while my people are dying, while my people are losing their lives. I'm going to emphasize the sentence written, the pursuit of reparation for the Mariana disaster. The disaster was not Mariana's disaster. It was BHP's disaster, Vales, San Marcos disaster. It was not of Mariana. It was of the companies due to their greed of using all of which motherland grants us. For me to be here today, I left at my house three children so that their voices in the future can be heard. Being a woman and occupying this place of speech is extremely important. And as women, we know how difficult it is to be within a place where the male words are more prominent, are more valued. And here I'm not alone. I carry with me the Krenak people. Anywhere I go is not Wakriwa. It's the Krenak people. My voice is my grandmother's voice because she was the one who said, go, fight. Djanira Jombre Krenak. She has been a very strong foundation for the Krenak people because she is the reason why we haven't given up yet. Because when we got to 2015, where the disaster, the crime of Valley happened, she was talking with an embargoed voice, with a crying voice, and she said, I want to go to the river. I want to see it. I want to say goodbye to the river. And she goes to the margins of the Rio of the Doce River alongside our family, and she does her last prayer, and she's in tears because she knows she won't be back, because she know that there we lost the river, we lost culture, we lost a part of our identity. And I say only a part because I lost Watu, but Watu is inside me. Because when we're talking about nature, we're not talking about something superficial. This is something that we live. And this is something that I can say that the river is a part of me. The culture is a part of Brazil. And it is shameful to know that now there have been 9 years after the event, and nothing was done. And when something is done, it is to remove the rights of the impacted people, the right to speak, to express themselves. And I'm here to say that we want justice, regardless of who doesn't like that. We want justice. Erehe. Erehe. Thank you, Wakrewa. Let's continue with our panel now with Marco Aurélio. And I want to now leave a few questions if Marco would already like to answer them, but also to Wakrewa and Gelvana. I wanted to know from your part, with the case going international, what does this represent to you, people impacted by the case? I believe, Felipe, that the main word here is hope. Because for 9 years now, we are trying to achieve justice and we have nothing. We have nothing established within Brazil, and what we have is our rights being taken away from us. The right of they are trying in a way to kill our people. And for us to try to find justice abroad, I believe that it is something like a fire burning within us. This fire is not has not died. It is still burning. And we know that money cannot pay for lives, as was said today. That the money will not pay for what was taken. But if I have a right to fight, I'll fight until the end, alongside Pogust. Thank you, Waka. Well, like my colleague said, what we have left, our hope is you guys. Like I said, in Brazil, we never had an option and we never had a voice. And here we do have that. And we have hope that justice will be made. Because the question, the matter that we all consider, those that were impacted, what are the foundations of the agreement that the governors will make for Mariana, since no person impacted was called to be heard? What are the foundations for this agreement of Mariana with the governors? What did they suffer due to that? As far as I know, nothing. Those are people that want to profit on the backs of the affected. We feel like an exchange rate. Who gives more? Who's going to get more? And the hope that we have is you, because many people still ask me, how much are you paying him? How much are you paying them? The foreign law firm. And the important case is they are doing something for us, something that wasn't done in Brazil. No Brazilian lawyer, no group of Brazilian lawyers were courageous enough to face BHP or Samarco, and you came all the way from England to fight that. And we are extremely grateful for you. Thank you, Giovanna. It is very satisfactory to represent you in England. This is a fight that we are very proud of being a part of. And I'm going to pass the floor to Marco. Good morning, ladies and gentlemen. I wanted to first thank you all. It is a joy and an honor being a part of this special panel, a panel that has a lot of symbolism. But before starting my speech, I wanted to excuse my friends Kakai, Eduardo Cardozo, friends, long time friends now, to salute the panelists of on behalf of Ana Prone and Carol. They are great models for us. It is a joy for us having them at this cause. Once they have their conviction, they get involved on the subject, and for us, this is something great. But before beginning my speech, Gelvana, I wanted to talk to you to say that they have a solidarity for your suffering, and I wanted to do that on behalf of everyone here. As a spirit man, the departure of someone so young, a 7-year-old child, this has a big meaning for us. So I think that in your struggle, you are bringing new meaning to this terrible situation. So I want to send you my hugs, my emotions, since this loss won't be in vain. Today in Brazil, we have 56 dams in a situation of danger. Many of those in the state of Minas. Situations like this one can be repeated if we're not successful in our attempt to bring in compensation. We'll have material damages to the people. It is hard for us to try to somehow have an actual dimension of the ancestrality we will never be able to reach. But so that similar situations do not continue to happen, we need to be successful in this lawsuit. 56 dams and 25 in a situation of risk. Brazil does not have different from aircraft accidents such as CENIPA. We do not have a specific agency to investigate these situations. This could be done by the mining agency itself, or perhaps create a separate agency. From this sad experience, we could somehow try to propose that. But before making my presentation, I wanted to register something after hearing these words of Kakai and our colleagues. We need to salute the efforts of the government of trying to reach a pact after nearly 10 years of this disaster. And here we're talking about a crime. We need to be clear about what we're saying. Vales and BHPs and Samarco's crime. It is as simple as that. They're trying to shield that, to bring that, to keep this obscure. But we need to say what is obvious. This is a crime, not just an accident, because the risk was undertaking in a dimension in the criminal law could be described as the eventual risk. You take the risk of reaching a result, be that whatever it is, and you are not concerned about it. This is what seems to have happened in that case. A number of measurements could have been taken to avoid this disaster, and your son would be here with us today. But sadly, those measures were not taken. And the criminal responsibility of Vale, of BHP, seems to be very clear. I cannot see how they can avoid that liability. But regardless of us recognizing and applauding the steps of the government of trying to find a pact, as Kakai said, at that table, we need to have the impacted people. You need to be heard. That is something that we should undoubtedly have. For those of you who have lost a river, we know how the originary peoples dialogue with that perspective. So there's no possible redress. I made a very quick registration, Wakari. What I'm seeing in those cases, Kakai, is that they're actually trying to obscure that with a discussion of jurisdiction. This has been surpassed. The lawyers that talked before me were very clear about that. It seems that the courts from England have the jurisdiction about that. We're talking about a publicly listed company, a global company that has a liability that they cannot overcome. So that the court from England has a jurisdiction and has a jurisdiction to apply the Brazilian legislation, as Eduardo Cardozo has said in some of the statements he made in a recent past. So I asked us to talk about these slides very quickly so that we have the exact dimension of what we're talking about.
To recover part of the meaning of this accident, of what are we talking about? While lawyers that stand for Valley and BHP are trying to turn that into a cold technical discussion, almost merely proceedings discussion, we have to recover that. The sixth at 16 hours of 5th of November, 60 million cubic meters of iron ore rejects loaded. This event is the largest environmental tragedy in Brazil, causing deaths, destruction of communities, plantations, contamination of water courses, and a devastating impact spread throughout the basin of the Rio Doce. And we'll follow this, one of the largest accidents in the world. Brazil had other accidents and knew how to work with the responsibilities we could not avoid knowing. Maybe because it's an Anglo-Australian company, it had a different behavior. We had recently an episode that could serve as an example. Regretfully, Valley and BHP ended up simply ignoring and turning their backs to this. We have abilities of trying to repair, mitigate what can be repaired and mitigated, but Valley, neither BHP ever worried about that. According to the Public Prosecution Office, 18 people died uh, buried under the mud, and don't want these situations to happen. That 41 cities, 3 indigenous reservations, 240 hectares of Atlantic forest, thousands of families hit directly or indirectly by harm caused during the Rio Doce Basin. 47 municipalities, anyhow, approximately 670 kilometers of rivers were contaminated. 670 kilometers of rivers were contaminated, mainly the Rio Doce, affecting areas of Minas Gerais and Espírito Santo states. These states, especially, maybe have the goal of, let's say, quickly celebrating this agreement because they want to cash in, and they lost the human dimension of this strategy. We can't stop reporting this, even because of the special situation of the Minas State. The responsibility of its present governor is in a difficult economic situation, so they want cash. They want to avoid the responsibility of analyzing the human dimension and want to cash in. So the reject mud affected the Bento Rodrigues municipality. Gelvana mentioned this specific situation. It's an extremely delicate situation. And the district of Regencia, in the municipality of Linhares, the preservation area damages were irreversible, almost 1,500 hectares of forest and areas destroyed. Meaningful figures that are being ignored. They see no one talking about this. What they're discussing is the so-called jurisdiction. And here's something very perverse happens. You know, as a good lawyer, you are. Kakai also had the opportunity of reading some things he wrote about it. When we get away from the event in time, the trend is for people to focus on their own lives. Everyone was sensibilized with the tragedy, but at some point the tragedy touched the hearts of each one of the people here and each one of the Brazilian citizens that saw by TV this horrid disaster. But as time goes by, people resume their routines and their lives, and discussion ends up cooling off. I think our challenge is to really provide a human dimension to this discussion. It's a huge challenge because evidently Vale as well as BHP are using the strategy of distancing and time of the tragedy to be able to discuss things they want to do it. And we want to recover exactly what happened in the country. Esteemed harms, material, environmental, damages, estimates from the Federal Prosecution Office, estimates of the English lawsuit, but doesn't come is not referenced. The Krenak people who lived at the margins of the river, one of the most affected parties of the because of the dam breach. That's something we have to recover and recover a lot. Other indigenous peoples like the Aurélio community in Espírito Santo were also hardly damaged. My time is almost up. I talked about lawsuits, but it doesn't matter too much. We do a criticism to Renova here, and as I have only 1 minute, I think the rest everyone knows. So I have no major concerns about this. Well, as my time is up, and I want to stick to my time. I just want to do this alert. I think this panel is of extreme importance. I would like to thank you once again for your courage, for your daring uh, action and reporting like you're doing. And our challenge is to provide this human dimension to this matter. Don't, and not let it get lost in these cold discussions in the courts. And it's not a small challenge. I think we have to do a new appeal to all players involved in this trial of agreement to do this report in the sense that in that table they are missing. So I think we have space to do that. And I think the time is now. But I want to thank you once again. It's a huge privilege to be here. I ended up be getting touched by your report in the beginning. So I was very touched, and I apologize, but it's a huge joy to be here, joining forces with the struggle, which is a struggle from all of us. Thank you very much. Thank you, Marco. Before we move on to Q&A, I just wanted to ask a last question to Akawawa and Giovanna, and I'd like to know what you expect for the next year for the English case. What do you expect as justice, or how are you feeling? How with the fact that after these long 5 years you decided to take the case to the English courts because you weren't getting in support in Brazil? The government suddenly wanting to close a new agreement without your participation, an agreement regarding your rights. Felipe, I hope there might be people from Valley or and BHP here, and I hope they are watching us in YouTube, on YouTube, even uh, influent people, and so this matter can reach the president of the company, and may we be able to stop that agreement if we're not heard. How are you going to establish an agreement negotiating lives where lives have no value, can't be negotiated? The river, the other people who were affected, involved. So I'd like to do that appeal, to make this appeal. And so when the agreement is done, if it's implemented, that we also are involved. Thank you, Giovanna. Would you like to say, Akrael? Yes, I bring in my shirt. If you can see, I'll ask permission to show. What if it would be your child? What if it would be your child suffering within the territory? If it would be your child without drinking water within the territory? What if it would be your child without a home to live in? That's what we are lacking. And the minds of human beings, this statement must remain. What if it would be you? What we expect from Brazil is that it would stop. It can't be dealt with, mentioned, and considered justice. Once I, Jovan, and the main ones hit harmed are not there, there's no way of that being justice. The governors, they weren't impacted at all. Impacted in what? Are they going to do what? My people, yes, is being impacted. Renova is in there renewing impacts every single day. Every single day in my village, there's a new impact. A child that could play and was free, had freedom, today does not. It's imprisoned within the territory. Can't leave the territory. The originary peoples, indigenous people have a collective culture themselves. My people today is imprisoned. How can someone live in a cage? How can someone live imprisoned? Drinking water was just served to me, and by drinking water, I remember my people don't have that because the water that's there contains rejects. And the springs that we have in my territory are very scarce. We don't have them. And what I expect from the next rulings that will happen now in October is that justice is really done. Justice is really served because the womb of a woman has can't be valued, can't have an esteemed value. How much is your womb worth when you consume contaminated food, contaminated water? How much is your life worth? How much value is your life worth? So that's the question I leave to you. Thank you. We can't lose the dimension that a penalty has a pedagogical and punitive repressive feature itself. And the pedagogical feature is reaffirmed in the example that that can't occur again. Vale and BHP must be hardly punished. This 100 million reais agreement is a joke considering the harm that was caused. I'm not talking about lives that can't be quantified in money, but I'm talking about the other damages, environmental damages for entrepreneurs, riverside communities that are really extremely expressive. Just I got news from the judicial about esteemed damages that are almost five times as much as the ones in this supposed agreement. If it's that's true, that should come to light, to come to the public, so people know that the reparation is poor, very poor, and so we must remind the victims affected that this agreement is being worked upon as something the final, decisive, and it's only a possibility. Evidently, the ones that want to carry on in their legal and their lawsuits will have the opportunity of doing that and will obtain in the end a result close to what eventually they would deserve to receive. Evidently, because no one deserves to have any kind of harm that can't uh, be paid for them. But we can't lose this dimension. This value is absolutely ridiculous. We have to announce that. I hope these studies come to light, come to the public swiftly, briefly. Thank you, Marco. I think now we can open for Q&A for the audience also. Good morning, everyone. My name is Ana Carolina, and my question is the following. There are many news that repatriation will be concluded soon. Nevertheless, you said you weren't even heard by the mining companies. What's your opinion about this agreement that's being implemented without the participation of the harmed parties? As I mentioned previously, it's absurd. It has no grounds whatsoever to do this agreement once we, the affected parties, are not involved. So there's no explanation. It's groundless. Where did they take this from? The governors, the public administrators do that, and we have no representative to stand for us, to represent us. So that's groundless. That has no grounds whatsoever. That took us by surprise. All victims. I have groups, and their question is that who from us will be heard? Wakiroa, Max, would you like to say anything and complement Giovanna's answer? Yes, it's important. Her question is important. Yes, she said we said that we weren't looked for, we weren't heard. We not only say it, we're stating it. That's the truth. We're not, no one's looking for us. And it's worth reminding the ones that are taking place in this repactuation can't say anything. Nothing of what's going on can be said because there's a huge, gigantic penalty because it's something very secret. And if there's something that's a large secret, justice doesn't fit this concept. So it's something that is going on behind closed doors. There is no harm people in the middle and amidst this talk, and we can't re uh, renegotiate something we didn't sit down to renegotiate. Just to do a compliment that we can state even without knowing the terms of the agreement, that is that it's not enough. There's a huge mistake of not listening to the victims really, but even for us to say anything about the agreement, it's very hard because we don't know the terms because of this confidentiality, except if you have some details. I particularly don't. By what I saw, there is a possibility for a large appeal to the federal government. The rest is states and municipalities, and an amount of indemnization that is precarious, insufficient, even offensive for the ones that want to adhere. By what we know, it's a general abstract feature. We know very little. It's a coward way of struggling, of litigating. How can we say anything if we don't know the terms? The agreement should be transparent, and it's not being so. The premises, the vectors are not known, at least to what it seems, by anyone in here. Except if I'm mistaken. Do you have any? Does anyone have any detail about this agreement? We have the idea that it's something around 100 billion that will be divided among municipalities, states, I think, and a specific amount inclusively is ridiculous within the agreement. By what was said, is something around 10 or 9% for the victims, for 700,000 victims, for the ones that should adhere, should want to join the agreement. So it seems precarious and insufficient and very little transparent. So we'll only be able to say something if we know the terms. For now, by the figures, we can say surely it won't be enough for the necessary reparation in this pedagogical feature of this penalty on Vale and BHP damage they must answer for. So they committed a crime and must answer for that, be in the English court, evidently, or in any other place. Thank you. Anna, do we have space for one more question or shall we close? So we are closing for today. I'd like to thank for the support from Media JOTA, thank our panelists, Marcos, Carol, Kakai, and our associates. And I'd like to leave only a closing statement for to finalize our panel. We were here today to deal with an extremely relevant theme, not only for Brazil, but for the world. The seek for justice and reparation of the environmental disaster cases that devastated lives, cultures, and ways of lives. This seminar went beyond the legal discussion. It's a call to action, an invitation for us all to recognize the depth of the crimes committed in tragedies such as Mariana and the urgency of building a model of justice that puts the people affected at the center of the decisions. In Brazil, we have witnessed a repeated cycle of omissions and disregards for the voices of those impacted by disasters such as the Fundão Dam collapse. Agreements between the states and companies responsible, Vale, BHP, and San Marco, are signed without the proper participation of those truly affected, like a Quilombola community. The other victims was known only now after 9 years of the disaster. It's in this context that strategic litigation presents itself as a necessary alternative, especially when the conventional system of justice fails or shows itself insufficient. Taking the case to a foreign court is beyond, above all, a way of claiming for justice that was denied or delayed in a world that's more and more globalized and is also a way of confronting the responsibility of corporations and the complicity of a state that doesn't protect its citizens and doesn't assure transparency and participation and due participation in the negotiations for reparation. Internationalization of cases like the Mariana case is not only a change in jurisdiction, it's a necessary breach due to the invisibility and environmental racism that permeate the treatment of victims in Brazil. By taking a case to a foreign court, above all, it's a way of claiming justice. And more than that, it's a way of reminding that responsibility of transnational corporations have no borders, such as the impact of their, as well as the impact of their actions. Unfortunately, environmental racism in Brazil is evident, especially when we talk about Quilombola communities, indigenous and riverside communities. These communities have been systematically excluded of the decision-making processes about their own reparations. Negotiations among states and responsible companies have been characterized by disregarding these parties. Talking about environmental racism is the erasure of the voices of these people. No agreement will be truly fair if it doesn't include direct participation of the people that have their lives devastated. And it's therefore we're here today to establish that the struggle for justice is not only about reparating the past, but about building a future where human dignity is at the center of the discussions and decisions. That's why in today's seminar, when we move towards closure, I invite you all to think on our role for the construction of a justice system that really represents effectively the interests of the affected parties, a system that transcends borders and that is so resilient as the ones that lost everything except the courage to keep on fighting. Thank you very much, everyone. Well, after the official picture to close this panel, I'd like to call the co-founder, CEO, and administrative associate of the law firm Pogust Goodhead to close the event.
I'd just like to thank everybody who has attended today and to JOTA and to the B Hotel for putting this event on. We've been honored by the presence of esteemed lawyers here in Brazil, victims who have been impacted, people who have contributed to allowing this lawsuit to proceed. And if I may just take a couple of minutes, perhaps just to provide a couple of concluding remarks on what has been discussed today. The first thing is just about whether we like it or not, we now live in a globalized world. It's impossible with the flows of capital, with damage to the environment, with the way that multinational businesses work, to simply limit justice to the borders of one particular country. And I think that's why we've titled today this Justice Without Frontiers. And that's not only in the environmental sphere, but in all spheres of law, whether it's criminal law, whether it's environmental, or whether it's financial transactions. So any attempts by those who have perpetrated crimes, and that's been a word which has been used consistently today, the environmental crime perpetrated by BHP, Vale and Samarco, to try to limit the effects of their crime, whether it's being held accountable here in Brazil or whether it's being held accountable internationally, ought to be deprecated and ought to be fought against. And I think that's a consistent theme which has emerged from all of today's panels. The second is the impact that this still has on the victims. We hear, of course, today from Racoewa and Gelvana about the daily impacts that this crime is having on them nearly 9 years after the disaster, and whether it's an amount of compensation and remediatory amounts which are agreed in the repatriation, or whether it's something which is finally obtained in England, or any different avenues in relation to relief that might be claimed against the companies. It's clear that no amount of money is able to provide people's lives to be brought back to where they were prior to this crime, or to remediate the environment. And in many ways, the financial elements or compensation are secondary to the word that I would use, which is accountability, a feeling of holding accountable, of obtaining justice, of obtaining an outcome there. And that's sadly something which those impacted by the disaster who I speak to nearly 9 years on don't feel. There are, however, green shoots of optimism that I would like to draw everyone's attention to. The case in London is proceeding on the 21st of October, so just over 5 weeks away. And I would invite everyone, I'm sure there will be extensive coverage in the media, as well as impacted people who actually have the opportunity through their lawyers to even observe the proceedings, or people who happen to be in London, to watch justice in action. And it is something, whether it's in Brazil and the extraordinary work that lawyers and judges and prosecutors and public defenders do here, or whether it's in London with judges and lawyers there, the mechanisms of justice which hold people accountable and hold criminals accountable ultimately are quite impressive to see in action. So I would invite everybody to watch what happens in London with a keen interest, and the office is available and in relation to any questions that anybody has about the case here. And then the last thing, we've heard a lot of comments about the repatriation and perhaps attempts here in Brazil to try to bring an end to some of the judicial claims that have been ongoing for nearly 9 years here in Brazil. But with that, and of course there is optimism I've seen reported about seeking to bring something to a conclusion, there has to be participation. And that has been something which is continually I have observed in this case ever since I've been involved nearly 7 years ago, are the impacted people not being listened to, not having a voice at the table, not being effective participation, and elites, whether they're in Brazil or they're in the UK or anywhere in the world, often have a very different view of what an effective compensation or what effective remediation or what effective justice looks like. And so it's the listening to the impacted people which is paramount. And yet, sadly, that appears that there are concerns and risks that the same thing may be happening again, and history repeating itself in terms of the impacted people not having a voice. So I would encourage everyone to listen to those. We've heard two of their voices today, but there are, by any account, over 1 million people, perhaps totally, who've been impacted directly as a result of the disaster, and hearing their voices through any process of remediation or reconciliation or compensation or agreement is absolutely vital. So I hope that no one would ever dream of making a deal of any kind in relation to this case without the impacted people being fully involved in it. And certainly from my perspective in relation to England, I can say we're ready to fight, and we'll be fighting the case against BHP in court on October the 21st. But any resolution to that case is contingent upon the impacted people having a say in it. And I trust that the same will happen here in relation to the repatriation. But thank you, everybody who have come today. And I think there are some coffees and other things available. And finally, thank you to Priscilla, who's our Director of Strategic Communications here at Pogust Goodhead, and has worked with JOTA and worked with the BA Hotel to put this all together. So thank you, Priscilla.